Welcome to VLearn Virtual Learning Network. This is session number 5 of Mercantile Law and the topic is Contract of Agency. Topics to be covered are different definition of agency, who can be an agent, difference between an agent and a servant, creation of agency, classification of agent, right of agent, duties of agent, and at the last, do it yourself. Now first, agent. According to section 182 defines an agent as a person employed to do any act for another or to represent another in dealings with third person. The person for whom such act is done or who is represented is called the principal. The relationship between the agent and the principal is called agency. Principle of agency. Contract of agency are based on two important principles. First one, whenever a person can do personally, shall also be allowed to be done through an agent, except in case of contracts involving personal services such as painting, marriage, singing, etc. Second, he who does not act through a duly authorized agent does it by himself, that is, the act of the agent are considered the act of the principal. This is according to section 226. Who can be an agent? Any person who is of the age of majority according to the law to which he is subject and who is of sound mind may an agent. The function of an agent is to bring his principal into connectional relations with third parties. The agent is merely a connecting link between the principal and the third parties. Or, according to section 184 of the Act, as between the principal and the third person, any person may become an agent, but no person who is not of the age of majority or of sound mind can become an agent so as to be responsible to his principal according to the provisions in that behalf herein contained. So from this it is clear that as between the principal and third person, any person may become an agent. Even a minor or person of unsound mind is not debarred from being appointed as an agent, but as a rule of caution they should not be appointed as agent, because if the principal appoints them, he undertakes a great risk, because whatever such incompetent person does shall be binding on the principal, but the principal shall not be able to proceed against the agent for his misconduct or negligence. Difference between an agent and servant. There is too much of similarity between an agent and a servant, as both are employed to act for and on behalf of principal. There is a lot of difference between the two. An agent has the authority to create contractual relationship between the principal and a third party, but a servant ordinarily has no such authority. A servant usually serves only one master, but an agent may work for several principals at the same time. A servant is generally paid salaries or wages, whereas an agent may be paid on commission basis. Thus, we found that an agent is not a servant. Now, scope of authority. An agent can create a contractual relationship between principal and third parties, but a servant cannot create contractual relationship between its employer and third parties. Remuneration. An agent receives commission on his services, but a servant is generally paid wages on salaries, on whose behalf an agent may work for several principals at same time. A servant can serve only one master at a time. Control. An agent is not subject to direct control and supervision of the principal. He is often discretion, but a servant acts under the direct control and supervision of his master and must follow all his reasonable order. Liability of principal. The principal is liable for all the wonderful acts of his agent, which are with within the scope of his authority, but the master is bound by the wrongful acts of his servant if done in the course of servant's employment. Creation of agency. Basically, creation of agency is divided into three parts: by express authority, by implied authority, and by ratification. Now, by implied authority is again divided into three parts. First one is by estoppels, second by holding outs, and third one is by necessity. Now, first one is express agency. When an agent acts within the scope of his authority, his act binds the principal as well as the third party. The agent derives his authority by the contract by which he is employed as an agent. So, this contract may be expressed or implied. According to section 186, a person may be appointed agent either by word of mouth or by writing. No particular form is required for appointing an agent. An authority is said to be implied when it is to be inferred from the circumstances of the case and things spoken or writing, or the ordinary course of dealing may be accounted circumstances of the case. Now take an example. A is reading in Delhi and he has an agriculture farm at Bombay. So A appoints B by the deed called the power of attorney as a farmer. In this way, the relationship of principal and agent has been created between A and B by the express agreement, that is power of attorney. Implied agency. According to section 187, an agency which arises from the conduct, situation or relationship of parties. An agency may be employed when it is to be inferred from the circumstances of the case, things spoken or writing, or ordinary course of dealing. Now take an example. A has a car but he cannot drive it. He allows his neighbor B to drive it. B, while driving the car with A, meets with an accident and injures C. C can sue A for damages because B is his employed agent. Agency by estoppel. It is the first part of implied agency. Agency by estoppel. According to section 237, when a person has by his conduct or statements induced other to believe that a certain person is his agent, he is estopped from subsequently denying it. Now, first of all, we should understand the meaning of term estoppel. The rule of estoppel says, where a person by his words or conduct has willfully led another person to believe that certain set of circumstances or facts exist, and other person has acted on that belief, then he is stopped or from denying the truth of such statements, although such a state of things did not exist in fact. For example, X tells Y in the presence and within the hearing of Z that X is Z's agent. Z keeps quiet and does not contradict this statement. Later on, Y enters into a contract with X, honestly believing that X is Z's agent. Z is bound by this contract, and in a suit between Z and Y, Z cannot be permitted to say that X was not his agent, even though X was not an actual fact his agent. According to section 237, this act deals with agency by estoppel. It says that when an agent has without authority done an act or incurred an obligation to third person on behalf of his principal, the principal is bound by such acts or obligations. If he has by his words or conduct induced such third persons to believe that such acts and obligations were within the scope of agent's authority. Agency by holding out. According to section 189, Though part of the law of estoppel, some affirmatively conducted by the principal is necessary in creation of agency by holding. Agency by holding out is a type of agency by estoppel. Here the elect principal by his affirmative or positive conduct leads other to believe that person doing some act on his behalf is doing with his authority. For example, a child purchases goods from his shop and desires the shopkeeper to collect payment from his parents later. The parents, though not bound to pay, make the payment. After a few days, the child again makes a purchase from the shop on the credit of the parents. The parents would be bound this time because by making payment earlier without raising any objection, they had held their child out as their agent for making such purchase. Now taken another example. A allows his servant to purchase goods on credit from a nearby shop, and later on he pays for such goods. Later on, when servant was not in A's employment, he buys goods on A's credit from the same shop. The shopkeeper can recover the price from A because A had held out the servant as his agent on earlier occasions. So, A will be bound for subsequent transactions entered into under similar circumstances. Agency of necessity. This arises where there is no express or implied appointment of a person as agent for another, but he is forced to act on behalf of a particular person. Sometime owing of the exigencies of circumstances, the law confers agency of some person to act as an agent of another person without waiting for the consent of that person. So, however, before an agent of necessity can be inferred, the following conditions have been satisfied. First, there should be an actual and definite necessity for acting on behalf of the principal. Second, within the available time, it should be impossible to obtain the principal instructions. Third, the person acting as an agent must have acted bona fide. Now take an example. A horse was sent by rail at the destination. It was not taken delivery by the owner. The station master had to feed the horse. Held, station master became the agent by necessity, and hence the owner must compensate him. Agency by rectification. According to section 197, when an agent does not act for his principal but without knowledge or authority, or where he exceeds his given authority, the principal is not held bound by the transaction. It means where acts are done by one person on behalf of another but without his knowledge or authority, he may elect to rectify or disown such acts. Example, L made an offer to X, MD of a company. X accepted the offer, though he had no authority to do so. L subsequently withdrew the offer, but the companies ratified X's acceptance. Held, L was bound. The ratification related back to the time X accepted the offer, thus rendering the revocation of the offer inoperative. An offer once accepted cannot be withdrawn. Classification of agents. There is one broad classification of agents: mercantile or commercial agents. It includes broker. A broker is a mercantile agent engaged to buy and or sell property or to make bargains and contract between the engager and a third party for commission. It means a broker is one who makes bargains for another and receives commission for so doing. He is an agent whose ordinary course of business is to negotiate and make contracts for the sale and purchase of goods, etc., of which he has neither possession nor control. He acts in the name of his principal. Second, factor. A factor is a mercantile agent who is entrusted with the possession of goods with an authority to sell the same. It means a factor is a person who is entrusted with the possession of goods and who has the authority to buy or sell or otherwise deals with the goods or merchandise or to raise money on their security. A factor usually sells goods in his own name. He has a general lien on the goods. Commission agents. A commission agent is an agent who is employed to buy or sell goods or transact business. It means a mercantile agent who buy or sell goods on behalf of his principal and receives commission for his service. Actually, it is not a different category agent because brokers, factors may also act as a commission agents. Del Creed agent. A Del Creed agent is one who, in consideration of the extra remuneration called a Del Creeder commission, guarantees that performance of the contract by the other party. Auctionaries. An auctioneer is an agent appointed to sell goods by auction. It means an auctioneer is an agent who is entrusted with the possession of goods for sale to the highest bidder at a public auction. He has the authority to deliver the goods or receive of the price. He can sue for the price of his own name. However, unlike a factor, he has only a particular lien on the goods of his charges. Banker. Though the relationship between banker and customer is ordinary, that the debtor or creditor, he acts as an agent when he buys or sells securities on his behalf. Pakka and Kacha Adatiyas. A Pakka Adatiya is a person who guarantees the performance of the contract, not only to his principal but also to the broker of the other side. A Kacha Adatiya does not guarantee the performance of the contract. Indenter. An indenter is commission agent who, for a commission, procures a sale or a purchase on behalf of his principal with a merchant in a foreign country. Non-mercantile or non-commercial agent includes wife as the agent. Second one is sub-agents. Another classification of the agents are general and special. Right of agents. Right to remuneration. According to section 219 and 220, an agent is entitled to his agreed commission or remuneration if there is no agreement to a reasonable remuneration. However, an agent who is guilty to misconduct in the business of agency is not entitled to any remuneration in respect of that part of the business which has misconducted. Right of retainer. This is also known as agent's right of retainer. It can only be claimed on money received by him in the business of the agency. He cannot therefore retain sums received by him in one business for his commission or remuneration in other business on behalf of the same principal. Right of lien. According to section 221, in the absence of any contract to the contrary, an agent is entitled to retain goods, papers and other properties, whether movable or immovable, of the principal received by him until the amount due to himself for commission, disbursement and services in respect of the same has been paid or accounted for to him. Right of stoppage in transit. This right is available to agent in the following two cases. First one is where he has purchased goods with his own funds or by incurred personal liability, like an unpaid salary. He enjoys the right of stopping the goods in transit if in the meantime the principal has become insolvent. Second one is where he holds himself liable for the price of goods sold. For example, Del Creeder agent, he may exercise the unpaid seller's right of stopping the goods in transit in case of buyer's insolvency. Right of indemnification. According to section 222 and 224, the principal is bound to indemnity an agent against the consequences of all lawful acts done by the agent in exercise of authority conferred upon him. Example, B at Singapore under instruction from A of Calcutta contracts with C to deliver certain goods to him. A does not send the goods to B and C sues B for breach of contract. B informs A of the suit and A authorizes him to defend the suit. B defends the suit and is compelled to pay damages and costs and incurs expenses. A is liable to B for such damages, costs and expenses. According to Section 224, an agent cannot claim indemnification for a criminal act even though the principal had agreed to do so. Example, A employs B to beat C and agrees to indemnify his against all consequences of that act. B thereupon beats C and has paid damages to C for so doing. A is not liable to indemnify B for those damages. Right to compensation for injury caused by principal's neglect. According to Section 225, the principal must make compensation to his agent in respect of injury caused to such agent by the principal's neglect or want of skill. Example, A employs B as a bricklayer in a building, a house, and puts up the scaffolding himself. The scaffolding is unskillfully put up and B is in consequence hurt. A must make compensate to B. Duties of agent. First one is to conduct the business of agency according to the principal's direction. This is according to Section 211. Second, the agent should conduct the business with the skill and diligence that he is generally possessed by person engaged in similar business. This is according to Section 212. Example, where a lawyer proceeds under a wrong section and thereby the case is lost, he shall be liable for the loss. Third one is to render proper account. This is according to Section 213. Rendering account does not mean showing the account supported by the voucher. Fourth, in case of difficulty to communicate with the principal, this is according to Section 214. Next, fifth one, not to make any secret profit. 6. Not to deal on his own account. 7. Agent not entitled to remuneration for business misconducted. Example, A employed B to recover rupees 10,000 from C, though misconducted the money is not recovered. B is entitled to no remuneration for his services and must make goods or loss. Now there are some questions on the basis of this session. First one is what is agency and how it is formed. Second one is explain the different rights and duties of agent. Thank you. Happy learning. We learning.